Imagine this: a business collapses, creditors lose everything, and the owner, the person who created the company, controlled it, and profited from it, walks away untouched. Not because they were innocent, but because legally, the company was a different person. Today, we're looking at the rule that makes this possible, and the rare moments when courts decide to ignore it. Before the late 1800s, running a business was simple and dangerous. If you owned a business, you were the business. If the business owed money, you owed money. If the business was sued, you were sued. If the business collapsed, you could lose your home, your savings, your entire life. There was no separation, no protection, no legal boundary between the owner and the enterprise. This made entrepreneurship risky, unpredictable, and often ruinous. And then came a man named Salomon. In 1892, Salomon ran a successful leather boot business in London. He decided to incorporate to turn his business into a company. He followed every legal requirement, formed a company, issued shares, appointed directors, transferred the business into the company. But when the company later collapsed, creditors argued something radical. This company is just Mr. Salomon in disguise. He is the company. He should pay the debts personally. Lower courts agreed. They said the company was a sham, a mere alias, a mask for Salomon himself. But the case went all the way to the House of Lords, and the judges delivered a decision that reshaped corporate law across the world. They said, a company is a separate legal person, even if one person controls it, even if it feels artificial, even if it seems unfair. From that moment, the modern corporation was born. A company could own property, enter contracts, sue and be sued, incur debts, and be responsible for its own liabilities, all independent of the people behind it. This is the foundation of limited liability, the idea that your personal assets are protected from your company's debts. It's the reason small businesses exist. It's the reason startups exist. It's the reason global corporations exist. The Salomon case is the case that made the modern economy possible. But separate legal personality isn't just protective. Sometimes it's brutally strict. One of the clearest examples is the Macaura case in 1925. Macaura owned a large timber estate and later sold the business to a newly incorporated company where he was the main shareholder. He continued to hold insurance policies over the timber, but in his own name, not the company's. When the timber was destroyed in a fire, he claimed under his personal insurance. The insurance company refused to pay. The House of Lords sided with the insurer. Because the company had become the legal owner of the timber, Macaura no longer had a direct legal interest in the property as an individual. He therefore lacked the necessary insurable interest. It's a harsh outcome that demonstrates the strictness of corporate asset ownership. Once assets belong to the company, they are no longer yours, even if you own every share. Separate legal personality protects owners, but it can also trap them. But this separation isn't absolute. Courts in the UK, Australia, Hong Kong, Singapore, Canada, and many other jurisdictions recognize rare situations where they can pierce the corporate veil, meaning they treat the company and the owner as the same person. But this happens only in truly exceptional cases. One example is fraud or sham companies. If someone creates a company purely to hide wrongdoing, courts may simply ignore the separation and treat the owner and the company as one. Another is evasion of legal obligations. If a company is used to dodge an existing duty, like paying debts, complying with a court order, or honoring a contract, judges can step in and look past the corporate structure. In some jurisdictions, courts also consider undercapitalization. If a company is deliberately set up with almost no capital to shield the owner from liabilities that were clearly foreseeable, the law may look behind the facade. And finally, there are agency or alter ego situations. If the company is effectively acting as the owner's puppet, with no independent decision-making of its own, courts may treat them as the same legal person. But here's the key. Courts are extremely reluctant to pierce the veil. It is a last resort, not a routine remedy. Most of the time, the company remains its own legal person, even when the outcome feels harsh. This is the price of limited liability. It protects honest entrepreneurs, but it can also shield those who misuse the corporate form. A classic example of veil piercing in action is the Jones and Lipman case in 1962. Lipman agreed to selling his house to Jones. Before the sale went through, property values rose, and Lipman changed his mind. To avoid transferring the property, he quickly formed a new company, transferred the house to that company, and claimed he no longer owned it. The court ordered specific performance, forcing the sale from the company to Jones. The judge described the company as a sham, a facade created entirely to evade a pre-existing legal obligation. The court pierced the corporate veil, treating Lipman and his company as the exact same entity to prevent him from committing fraud. It's a textbook illustration of when courts are willing to step in. When the company is used as a vehicle for evasion or deceit, the law may look past the corporate mask. Separate legal entity isn't just a historical doctrine. It affects small business owners, directors, shareholders, employees, creditors, consumers, and anyone who interacts with a company. It's why your personal savings are safe if your company fails. It's why investors can take risks. It's why corporations can grow across borders. And it's why courts must carefully balance protection with accountability. The entire global economy rests on this one idea. A company is a person, but only sometimes. So here's the question I'll leave you with. Should the law make it easier to hold owners personally responsible when companies cause harm? Or would that destroy the very idea of limited liability? If you enjoyed this video, feel free to follow the channel for more.